everybody who is on. We appreciate you being here today. Joel is going to go through the changes in the contracts, and then what we're going to do is hold all the questions until the end. There is a Q&A box, so just put your questions in there and Joel will answer those all at the end. So Joel, thank you for being here today. Really appreciate it. This was a culmination of a little over a year's work, and we're still working on some additional things. So thank you to Joel. Thank you to Greater Gateway, because we do these contracts in conjunction with them. So thanks to them. And take it away, sir.
All right, great, thank you. All right, so this is the fourth or the fifth time that we've done this. Each time we've gotten a little bit better and gotten a little bit faster. So I guess this is probably going to take about half an hour or so today before we get to the questions. What we did is, over the course of the last year to year and a half, there was a couple of different committees and task forces that were created to kind of go through the existing contracts. They do this every several years. Came up with a list of changes that wanted to have implemented into the contracts with an aim towards making them better, more user-friendly, building in more worker protections, and making them just more accessible and user-friendly in general. On the first slide, Deb, if you want to change it, you'll see that there are several. It's just a summary of the contracts that were changed. So we made changes, some significant changes, some not so significant. As we get through today, we'll see a lot of the last documents are very nominal changes. But ultimately, this is a summary of the documents that were changed. There's one additional document there. We created a new form, and we'll talk about it when we get there. It's the cancellation form, and that was created because of some changes we made to the contract itself as it related to earnest money. So we created a new form, not on that list yet, called the cancellation form, and we'll discuss that as we get to the earnest money section. First and foremost, one of the biggest questions that we have had over the last several years is how to and what to do with termination and earnest money issues. As it was before, the two were married. So you couldn't terminate without addressing the earnest money release aspect of it. And oftentimes when there was a disagreement between the parties, they could probably agree to terminate, but they would not agree on the disposition of the earnest money. So the decision was made to actually bifurcate them and create two separate forms. So where now you'll have what is a termination notice and an earnest money release. And you can go to the next slide. The termination notice, the earnest money, I guess is the first one. The earnest money really says exactly what it said before, although now we've created an option to terminate the contract and not release the earnest money, or agree to continue to disagree on the disposition of the earnest money, in which case you would go through the small claims or the other arbitration dispute resolution provisions as it related to the earnest money only. Top section of this form is, for a full return and refund of the earnest money to the buyer. The second, or the bottom half of this form, is now similar to what we had before on the dual notice, where you could allocate a percentage of, or a portion of, the earnest money to be returned to the buyer and some of it to be kept and retained by the seller. So it functions exactly like it did before. It now just allows for us to terminate the contract, as we'll see on the next form, but not necessarily release the earnest money. So in the termination notice, exactly what it was before. It's just now we're separating it and not dealing with earnest money release at the same time. So if you want to have a full termination and a refund of the earnest money, you need to sign and execute both forms. And importantly, both documents require signatures of both parties. This is not changing the dual consent requirement of the termination. It's just saying we can terminate and still retain the right to disagree over the disposition of the earnest money. Changes to the contract, starting at the very beginning of the contract in paragraph 5, we made a couple of changes really to kind of govern the earnest money. There's been a lot of concerns over the timing of earnest money deposits, the promptness of the deposits, whether the deposits are made to the title company and or the broker consistent with license law expectations. So what we did is we changed it from deposited to delivered. Obviously, as brokers, you cannot control the deposit of the earnest money, but you can control the delivery of the earnest money. So we've now built in the requirement that earnest money has to be delivered within blank business days. That was really just a calendaring clarification. Obviously, we're not going to be delivering on non-business days, and then business days are defined later in the agreement as Monday through Friday and during normal business hours, but that's defined later in the agreement as well. One of the bigger changes came out of, and I had referenced it when we were talking about the cancellation form and the creation of the new form. One of the bigger changes is in that second half of 5 there, where we've built in a provision that if the earnest money is not delivered within the time frame required in the contract, so in the blank that was just above, the seller may cancel, not terminate, may cancel the contract by notifying the buyer within 5 days after the required delivery date. So what we created, and we don't have it because it was literally just approved this morning, but what we have created is a very simple 1 paragraph, probably 3-line document that basically just resuscitates that the seller is choosing unilaterally to cancel the contract for failure of the buyer to provide the earnest money deposit as required under the contract. That will be a new form that will be added to your forms list, and it should be used for purposes of unilateral cancellation when the buyer does not perform under the earnest money requirements. And that's the sole purpose of the cancellation form. There was some discussion about using it for other purposes, and it was determined that it wasn't necessary. So the only reason that we're going to be using the cancellation form now is if the earnest money deposit is not made and the seller elects to cancel, not to terminate, but to cancel the contract, because the seller in that sole instance is able to unilaterally cancel it and move forward without having to adhere to the termination requirements. There was quite a bit of discussion on in different iterations of the home warranty plan. Ultimately, the decision was made and has changed since the first time that we discussed it, to where we are wanting brokers to put in with specificity the dollar amount, and my recommendation is the desired plan for the home warranty plans. Goal being consistent with best practices, be as specific as you can so that there's no room for error and there's no room for disagreement as far as what the buyer and the seller have agreed to as it relates to home warranty provisions. So as it reads now, and as far as I'm aware, this is the final version of it. Home warranties, then you got the 2 check boxes, either is waived or provided by, and then it's either provided by the seller. At a cost, I'm reading the red line, at a cost of X dollars. So put in the exact dollar amount of the plan that is desired. And then I recommend, if you can, put in the name of the plan so there is specificity as to what the parties have agreed to. And then if a seller gets this and does not agree, then you would just do a counter offer like you would for any other type of contractual provision, just like you would for a price or an earnest money or a closing date. Go back and just do a counter offer and say, I'm only going to provide this plan, not the one that Mr. or Mrs. Buyer has asked for. Paragraph 7 on the inclusions and exclusions. We'll talk about it here, but it's also, there's a mirror, obviously, in the listing agreement as well. Ultimately, all we did was clarify on a couple of instances what the inclusions and the exclusions were. We added the smart home technologies, added in irrigation systems, clarified the mirrors that are to be specifically included. Just like before, this can be added to or subtracted from. And when we get to the listing agreement, you'll see it's the same list. I always advise people, brokers to make sure that to go over this list with their clients, and if there are specific inclusions or exclusions that the clients do not want included, meaning there's items that they definitely do not want included in the conveyance of the home, those need to be listed as exceptions in the listing agreement. And then brokers need to make sure that they're also listed as exceptions or exclusions in the contract itself. So this is meant to be a guide list, but it can be added to and subtracted from based on the individual property and the client's instructions. The paragraph 8, we made a handful of changes. The primary one being we just defined what the closing is, and that's the time in which the title company confirms that the buyer's funding has been received and dispersed and all pertinent documents have been signed by all parties. That's important because it's used as a defined term throughout the contract, and we just wanted to have some clarity as to what actually constitutes a final and binding closing for purposes of closing out the file and the conveyance. Another thing that I know brokers wanted, and frankly title companies wanted as well, was some type of clear authorization within the contract to make it clear that all parties were to be entitled to receive copies of the settlement statement. So as it's done now, the buyers and the buyer's agents and representatives have the right to see their side of the listing of the settlement statement pre-closing. The sellers and the sellers representatives and agents have the right to see the seller's side pre-closing. And then after closing, both parties have the right to see and have a copy of the entire settlement statement. That was important so you can get rid of some of the privacy concerns, and we're giving specific authorization to the title companies now to share that information with the brokers. And then the very bottom down there, seller grants buyer and buyer's designated agent. What we've done there really is just to clarify that all utilities are to be kept on all the way through the closing date, and that they are to be kept on at the expense of the seller. It's common sense. The seller has legal title and equitable title up to and including the closing date as it is, but we wanted to clarify within the contract the utilities have to be left on, and that it is at the buyer, at the seller's expense through the closing date. Buyer takes over on the day after closing. Paragraph 9, there was quite a bit of discussion over the course of the last year and a half about what exactly constituted pre-approval and what are the brokers looking for, what are the buyers and sellers and clients looking for, what are the lenders looking for and comfortable to give. Ultimately, the decision was made after quite a bit of diligence. We went back and looked at the Consumer Financial Protection Bureau and how they treated pre-approval letters and pre-approval conditional pre-quals, and came up with the opinion that CFPB was treating them as pretty much having the same meaning and synonymous. And if that was what the CFPB definition was, we felt that that was probably consistent with the intentions of our contract as well. So we just made clarification there. We've now called it the conditional pre-qualification / pre-approval letter, so that it was clear in the eyes of lenders and of brokers really what we were asking for in advance of any type of diligence and financing process, the application process through the lenders. At the outset, they can run a credit check and they can get an idea of whether you meet the minimum requirements. But at the time the contract was drafted, presumably they have not been able to do any of the diligence that's required to go through the full financial application and mortgage application process. So we now just clarified that, and in the next paragraph down, the timeline for all the parties to be acting in earnest. So the next paragraph down says that the buyer is required to, we took out immediately and we put a timeline on that So now required to, within 2 business days after the effective date, apply for the financing indicated above, and that the appraisal has to be ordered and returned consistent with the finance contingency deadlines. So the appraisal now needs to be returned. The appraisal, I believe, has to be ordered within 10 days now. I'm gonna look at the contract. Yeah. So the appraisal has to now be ordered within 10 days after the effective date and obtained no later than the finance contingency deadline. And that's important because a lot of times the inspections may not have been fully completed yet within that 10-day period. And the decision was, that's okay. In order for the buyer to be considered to be acting in earnest, the buyer needs to be pursuing the finance, pursuing its finance options and obligations. And the appraisal obviously is a big part of that. And if we delay ordering the appraisal until such time as we've got through the inspections, then you're finding it very difficult to get the appraisal back and approved in a timeline consistent with meeting the finance contingency deadline for purposes of the contract. So we tied an order deadline within 10 days of the effective date, deeming that that was a reasonable amount of time for everybody to kind of get through that first step of the application process and make sure that they were all moving in the right direction. And then it was on the buyer to go ahead and instruct the lender to order the appraisal so that the rest of the timelines could be met. And then no, go back a screen, I'm sorry. We added in that third paragraph down, we added in, just for clarification purposes, that if the finance contingency deadline passes without written notice as outlined above, buyer remains obligated under the contract. That's common sense. That's the way it's always been in practice. But the committees determined that they wanted to have some clarification in the contract so that all parties were aware that if they did not adhere to the timelines and they didn't provide the proper written notices, that they were going to be deemed to have been waived and that they were going to have to then continue to be obligated under the contract to perform under the contract. And then the very bottom down there, that is added in another checkbox to indicate that if there's any grant monies that are being used as part of the purchase price, that they would check that box and indicate that the grants are being used to offset some of the purchase price. Oh, I jumped ahead a little bit, I guess, because there's where we talk about the appraisal. But there it is in the change in writing that the appraisal has to be ordered by the buyer or the buyer's lender within 10 days after the effective date and obtained no later than the finance contingency deadline. Property inspections made a handful of changes. The first two that you'll see there in the middle, we just struck out references to mold and mold infestation. That really kind of came in the direction of NAR and Illinois Realtors, largely because there is no working definition of what mold is and what constitutes good mold, bad mold. And you guys as brokers are not mold experts. So the decision was just to take it out of the contract entirely. And you'll notice that there's also no longer a mold disclosure form. There hasn't been one that was in use for some time. This was just a clarification within the contract to go back and catch it and take it out. And you'll see in the listing agreement that we took it out of there as well. The middle section there that's bolded, that truly is all that was added. We added in the sentence that the buyers further agrees that minor repairs and routine maintenance do not constitute a material defect. Ultimately, there was a lot of discussion within the committees trying to figure out what was a fair inspection issue versus a non-fair inspection issue in an effort to preserve the integrity of the contract and offer some protection and guidance to the sellers as well, to ensure that buyers weren't going into contract and then terminating contracts for reasons that were really more cosmetic type. The contract had always read that cosmetics were not an allowable reason to terminate the contract, but we felt that it wasn't clear enough within the old language. So now we've added in the language to make it clear that the major components are what is to be considered inspection remedy items that are covered under the inspection notice, not non-major or cosmetic type items. So specifically it says, the request for repairs shall cover only the major components of the real estate limited to HVAC systems, plumbing and well system, electrical system, roof, walls, windows, doors, ceiling, floors, stairways, appliances, and foundations. This is important. A major component shall be deemed to be in operating conditions and therefore not defective within the meaning of this contract if it does not constitute a current threat to health or safety and performs the function for which it is intended, regardless of age, or if it is near the end of its useful life. Minor repairs, routine maintenance items, and painting, decorating, or other items of cosmetic nature, no matter the cost or remedy, do not constitute defects and are not part of this contingency and shall not be a basis for the buyer to cancel this contract. So that goes quite a bit further than the other contract. I think it's consistent with the spirit of what has always been in the prior contract, but we wanted to make sure to alleviate any ability for buyers to abuse the contract as it was before. So I think that's going to take a little bit of a different thought process from buyer's agents as you're going through the inspection results. You want to make sure that the items that are being asked to be repaired and dealt with, excuse me, are major structural components and that they are deemed to be defective within the meaning of the contract. Government inspections. Nothing really changed here other than clarifying that it is the seller's responsibility unless specifically stated otherwise. And there are some municipalities that do pass the burden on to the buyer to obtain occupancy inspections. But by and large, the contract requires and states that the seller is obligated to, within 5 days of the effective date, order and calendar and schedule the occupancy inspection to the extent that one is required. If it is not specifically stated or not specifically left to either the buyer or the seller to order, then it's deemed that it is the seller's responsibility under the contract. And that's that last sentence there in that paragraph. And then we added in that if any reinspection is required, that is to be done at the seller's expense unless otherwise agreed to or specified within the codes. Paragraph 16, we have always had constant dialogue and communications on how to work with and improve the taxes and assessments sections. Unfortunately, with the state of Illinois taxing so far in arrears, there's never a great answer. Several years ago, we had changed it to increase the discrepancy amount from 200 to 500. This go round, it's become an issue where we've noticed that particularly in St. Clair County, probably lesser so in some of the other counties, but particularly in St. Clair County, Illinois disabled veterans have a standard homestead exemption on real estate taxes that could be all or any portion of their tax bill, their real estate tax liability, depending on the nature and the extent of their disability. So it is now structured to clarify that if a seller is a disabled veteran and has a reduced real estate tax liability because of this homestead exemption, because of their disability, they are not bound by the $500 over or under, what I call a true up. They're not bound to the true up provisions of the contract, and the buyer is taking the home subject to what the standard real estate tax rate would have been, but for the homestead exemption for the disability. That is now specifically excluded and accepted from the contract. And you'll see that we added in a provision on the listing agreement to try and help guide the brokers early on as they're making these determinations, so that buyers are at least informed and have a better idea going into it pre-closing that their real estate taxes are probably going to be considerably higher than what a disabled veteran seller's real estate taxes are. And then we added in, we just brought into the definition of what electronic signatures were. They've always been allowed. We've now just clarified that electronic document platforms, which is intended to be a much broader, much more all-encompassing provision than what was there before. So on the earnest money, in addition to the changes that we made as far as the delivery of the earnest money, the committees wanted to clarify and add in language that not only can brokers hold earnest money, but more likely than not, and in most cases, it is not a broker that's holding the earnest money, it's a title company or other third party. So for purposes of paragraph 25, when we're talking about the impacts of license law, and we're talking about the broker's responsibilities for holding and treating earnest money as being abandoned, we wanted to clarify that those rules don't necessarily apply to title companies who are not subject to license law and are subject to, but are subject to their own rules and regulations, and brokers are protected outside of the contract to the extent that it's held by a title company. So that was really just a clarification point there. Mediation, arbitration, litigation. We'll talk about it here. Same language is also in the listing agreement. What we didn't change anything as it relates to the arbitration and mediation provisions. Those are still governed by the NAR process. Those are still the same exact process that it has always been. What we did change, based on the fact that different counties have different requirements for what constitutes small claims and what the process is for bringing and prosecuting a small claims matter are, we took out the standard the blanket $5,000 cap out of the contract. And instead, we've now set it to be whatever the maximum threshold is for the county in which the real estate is located. And we have tied in the county procedures for filing of small claims. The goal there was simply to allow for the maximum recovery and the maximum efficiency of any type of contractual dispute, and to make sure that it's shepherded through to the maximum extent possible through the county where the real estate is located, through that county's small claims processes and procedures. I mentioned at the beginning that we had changed or added to the definitions of business days. So you'll see at the top of this slide in paragraph 28, we've just added clarification that business days are to be considered Monday through Friday from 9 a.m. to 5 p.m. And then the acknowledgement section is a new section. It's in addition to the previous section. And the thought process here was, we really want brokers to be making the disclosures in a timely fashion. But to the extent that they are not making and providing the disclosures, so we're talking about the real property disclosure, the lead-based paint, and the radon disclosure, to the extent that those disclosure documents are not being provided in the MLS in advance so that buyers can make an informed decision, having reviewed them prior to writing a contract offer, now we've built in a timeline in which those documents have got to be provided, and we've tied that into 3 days after the effective date. and they can be provided all at once or they can be provided separately. In either event, the buyer has 5 days after they have received the documents. So whether they're all received at once, they're 5 days from receipt of all 3 documents. If they're received separately, it's a 5-day period from the receipt of each disclosure document. And during that 5 days, they can review and they can terminate or withdraw their contract.
And best practice on that, Joel, we had talked about is uploading those into Maris so that the documents are just always there for the buyer's agent, so they don't have to call you as the listing agent. And that way you don't even have to deal with this clause because it is right there.
Correct. Yep, that's correct. That's what I was saying at the beginning was, you know, to the extent the brokers have not already done that, which is definitely the best practice. This provision is really meant to govern the situations in which the brokers have not provided them in advance. The non-discrimination, we just made a couple of changes to bring it consistent with NAR and Illinois Realtor Standards. We do that periodically. You'll see that that's also in the listing agreement as well. We just update those periodically as the definitions and the classes and groups change. And then the end of that, we have changed a couple of things. There's a couple of red lines there that you'll see. We added in production under so that there's a ready mechanism for everybody capturing their metrics and wanting to make sure that their production goals and production numbers are consistent. We added in the acceptance / counter offer deadline information there, because the decision was that an acceptance isn't the only thing that a seller can do when they receive an offer. They can either accept it, they can counter offer it, or they can do nothing. Before, it was just either an accept or do nothing, and very clear, a counter offer is another form of a response. So now we've added to the contract to make it clear that that is an acceptable response, subject to the same acceptance deadlines. Or excuse me, subject to the same response deadlines. And then the last one was just a clarification, just a clerical issue to change from listing agency to agent. The contingency on sale and or closing of the buyer's property addendum A. All we did there was take out the B portion, just deleted out the language saying that the buyer shall deposit additional earnest money as earnest money within blank days. So now it just reads, that the closing date shall be the earlier of the date in section 8. So that's all in paragraph 5 of the contingency. And we just struck out B entirely and retained A entirely. There was no changes in substance beyond that. On the counter offer to purchase real estate, we didn't make any changes substantively. The only change that was made was to bold that entire paragraph there in the middle, really just to put everybody on notice that the counter offer supersedes the initial offer, and that any provisions of the counteroffer that are inconsistent to or different from the offer are considered the changes, and that going forward, they are the ones that would, they'd be the enforceable provisions. On the inspection response, a couple of changes. One was, again, kind of listening to what our lending affiliates are telling us. They still do not want to be in a position of lending or advancing or making mortgages based on personal property or any issues related to the personal property or inspections. So one of the options that was added was a new checkbox there in the middle to allow for it to be clear a monetary contribution to be made by the seller. It doesn't have to necessarily be, or sometimes can't be, determined to be a credit at closing payable directly to the buyer. So the lender wants to see it shown as an offset towards the closing costs. So now we have a checkbox to allow for that in those instances. Importantly, it needs to be made clear that that still does require an amendment to the contract at that point, because you're changing the flow of proceeds. And then the next one down, you'll see that we struck out A, and looking at the actual inspection response, that is buyer acknowledges seller selection above and responds as follows. Buyer accepts the seller's proposal under option A or B above. Well, under option A above, the seller has already agreed to do what the buyer has asked. So the buyer does not need to acknowledge seller's acceptance of those terms. It's already, the contingency has been satisfied at that point and is no longer an issue. So there is no reason for buyer to acknowledge and accept seller's proposal under option A. So we just deleted that reference and now have it now just reads buyer accepts the seller's proposal under option B above, A already having been satisfied. So this document really truly, for the most part, speaks for itself. We had a counteroffer withdrawal before. We now have created a new offer withdrawal because an offer can be withdrawn at any point in time before it is signed, whether it's before it's accepted or countered by the seller or by the receiving party, I suppose. So we just made a new section to make it clear that an offer dating of the initial offer relating to the real property is withdrawn effective such and such date. And that's done unilaterally by the buyer because the buyer, presumably because the buyer is the one making the offer there. The counteroffer portion is the same as it was before. Possession by buyer prior to closing. Ultimately, nothing changed here with the exception of we added in a new checkbox there in the middle under number 7 to allow for limited purpose access prior to closing. The balance of the document's the same. It's still intended to be a limited purpose access prior to closing no matter what. I always advise if you're having more than a very limited purpose access prior to closing, you really want to look at a lease and not deal with this form. This is intended to be for very short term, very minimal access and possession. The checkbox was added to give owners or sellers an option to allow buyers minimal access to garage space only, meaning not the residence itself. Ideally, this would be used for temporary storage of boxes or furniture or something, immediately pre-close. But again, it's intended to be a very minimal, limited use. All right, listing agreement. Throughout the document, really globally, you'll see, and you see it here on the first page, but throughout the entire document, we made these changes. We have changed managing broker and replaced it with sponsoring broker. We did that because it's consistent with license law, and it's the sponsoring broker who is ultimately responsible and obligated under the listing agreement. And then there was use of the term designated agent below or before. We've now just clarified and given it a definition to where designated broker is now defined throughout as the designated agent, and made those changes throughout the document where appropriate. I mentioned before about the tax exempt and making a couple of additions to the listing agreement. This is one of them, line 15 there. are you exempt and what type? This is where you would put in the veterans disability, any other type of homestead exemption, senior freezes, any type of exemptions that are going to impact the existing real estate tax structure. It's important to go over this with your sellers so that you guys know when you're marketing it. And I would encourage, if it's possible, to put it in the MLS, in remarks or somewhere else, maybe in agent remarks, somewhere, just so that everybody's operating on the same playing field before the title work is done and before the closing settlement statements are done, so that everybody's aware of the current tax structure, so that buyers have realistic expectations going into closing and aren't caught off guard at closing, or worse, when they get their tax bills a year after closing. The next one down is we added in the line about subdivision or HOA fees. Again, just so that it's an educational piece, so that you guys are given the information up front and have an ability to work with the title companies to make sure that they have the information that they need to be able to process the closing in a timely fashion. And then we talked about it, but the inclusions and exclusions of paragraph 3, those are the same list that was in the contract. Paragraph 5 of the listing agreement, there was quite a bit of discussion about how the commissions are determined, and is it based on a percentage of is the split based on a percentage of the seller's commission? Is it based on a percentage of the sales price? Some hybrid of the two. So the decision was to actually make the commission as a percentage of the sales price instead of the total commission. Works out the same, maybe a little bit of math difference to get there, but ultimately they thought that it was clear to have it be defined directly as a percentage of the total sales price. Discrimination, same as what we talked about before, and the paragraph 13 disclosures, just taking out reference to the prior mold disclosure document and the requirement that any disclosure documents or any mold disclosures be made. So paragraph 18 is new, and maybe not new, but entirely revamped. It was changed to incorporate the provisions as it relates to the government inspections directly out of the contract. And it was added here so that sellers were made aware early and often, but made aware early as to what obligations and what their expectations were going to be, or what the expectations of them were going to be throughout the contract process, so that they could get a head start on any type of inspection related issues that were going to be necessary to pass inspections, and that they knew that that obligation was theirs. Paragraph 20, the only change that we made, and this is the same in several of the next several slides, just replacing SUR MLS with Maris, consistent with a move from the MLS system from the SUR MLS system over to Maris MLS. Paragraph 21, the same exact language that was in the contract, just changing the small claims maximum thresholds to be consistent with the county in which the real estate is located. Same process, same thresholds. On the list of addenda, we took out reference to the mold disclosure for the same purposes we discussed before. And then we added in new signature lines to clarify the sponsoring broker management relationship, to where it now reads signature sponsoring broker or the designated managing broker on behalf of the sponsoring broker, which should be the correct signature block and line to be consistent with licensed law. The addendum for the one-time listing agreement, the only change that we added there was the highlighted portion there in red. just to make it clear that the listing agreement, in order for it to be a valid addendum, there has to be an underlying listing agreement, and that listing agreement needs to be attached to the addendum for purposes of your record keeping. The next 3 slides, the listing amendment, the listing termination agreement, and the listing withdrawal agreement. The only change that we made in each of those 3 documents was to replace Sur MLS with Maris MLS so that it is consistent throughout. And then the last document there is, it's not a new document, but it's a complete new version or new form of that document. And it was expanded really to collect the information from the sellers as it relates to their mortgages and their lines of credits and any type of encumbrance against the property, so that that information was ready and able to be given to the title company so that they had all the authorization and information that they needed to be able to communicate on with the title, with the lenders, to make sure to properly facilitate closing documents and loan payoffs. That should be done in addition to, my opinion, it should be done in addition to the client intake forms that most managing brokers have. Those are used as roadmaps for brokers to make sure that you're getting all the information applicable to the listing, so that it's all there in one place. And when you actually get a contract, you're able to streamline the process of moving it from offer to contract and contract to closing. So that is it for the changes. And I have not been following questions, Deb, so if there are questions.
Not yet, but I have 2 things I want you to, well, the first one I'm going to address. I've gotten a lot of complaints recently that the buyer's closing costs are being put in special agreements rather than in where it belongs in the sales contract. Problem was, when we first kicked this off with .loop, that line was not there. I had to go back. .loop, bless their hearts, made many, many errors for us. Thank you very much. And so we had to go back and put some lines in. That was one of them. So agents should now be putting closing costs in that specific line. The other thing I wanted you to address, Joel, is I keep hearing over and over again that appraisals are being waived, and that is not the right verbiage. So I want you to explain what the correct verbiage is.
I don't know what the correct verbiage is, but the process is, I mean, obviously, if a loan, if a purchase is contingent on financing, then it is also contingent on appraisal, because nobody's going to be able to get financing in place without the bank doing the appraisal. You know, we mentioned it earlier, the lender really controls the appraisal process. The only thing that brokers can and should do is make sure that their buyers are, you know, honoring the timelines within the contract and making sure that lenders are ordering the appraisals. But the appraisal itself is not something that can be waived. And that's not true. It can be waived on a cash deal, but it is not something that can be waived if there is financing in place. So when people are saying that they are waiving appraisals, they can't. You can't waive an appraisal and have a finance deal. Ultimately, what they are doing is they are waiving their right to object to an appraisal that comes in low, and they have to be prepared to cover the offset and cover the excess beyond what it appraises at. As far as language, I don't have magic language to put in there. I don't like waiving them. I think it's a crazy idea to even reference a waiver of it. I know that it's happening. Ultimately, a buyer, brokers need to educate their buyers that if they go in aggressive and they put in magic language like we're going to waive appraisals, that's great for purposes of the contract, but they have to be prepared to cover the difference, because what they're waiving isn't the appraisal. They're waiving the contingency, meaning if it doesn't appraise out, they are still bound by the contract, and they've got to be prepared to cover the shortfall.
And that's exactly what I wanted you to explain. So thank you. All right, so if you have questions, please put them in the question and the Q&A down at the bottom of your screen. I'm gonna stop the share here. And right now I don't have any questions.